Bem, um bom dia a todos e a todas. Nós vamos iniciar mais um painel do 9º Congresso Brasileiro de Direito Tributário Internacional, online, na modalidade online, sobre tributação internacional e recuperação econômica, sobre o papel dos países emergentes. E o tema desse painel, que vai das 10h30 ao meio-dia e 15, é o conceito de beneficiário efetivo pós-BEPS, medidas antiabuso e compliance financeiro. Para esse painel, nós teremos a participação importante aqui do moderador, Dr. Perisson Andrade, mestre pelo IBDT, e grandes nomes, ícones do direito tributário internacional, como o professor Blazej Kuzniacki, professor da Universidade de Amsterdã, na Holanda, o professor Philip Baker, professor visitante da Universidade de Oxford, Inglaterra, professor João Felix Nogueir, professor da Universidade Católica Portuguesa de Portugal, a professora Patricia A, professora da Universidade de Miami, Estados Unidos, e a professora Jennifer Roeleveld, professora da Universidade do Cabo, África do Sul. Então, nós teremos aí um painel com muitas apresentações, um tema extremamente instigante, e eu passo imediatamente a palavra ao nosso moderador, Dr. Perisson Andrade.
Olá, bom dia a todos, tudo bem? É um prazer e uma honra estar aqui. Obrigado, IBDT, pelo convite para moderar esse painel interessantíssimo. Como o professor Paulo já adiantou, teremos os maiores tributaristas internacionais no assunto, num painel muito instigante, beneficiário efetivo, um assunto altamente polêmico, não pacífico, nem mesmo na doutrina, nem na jurisprudência. Então, os nossos palestrantes irão falar um pouco da sua experiência pessoal e de case laws da Europa, dos Estados Unidos, da França, Dinamarca e outros, e também da perspectiva que existe em relação a esse instituto anti-avoidance restrito a pagamento de dividendos, juros e royalties, se é uma norma que deve ser interpretada do ponto de vista unicamente jurídico ou também econômico, com uma visão da substance over form, coisa que nós exploraremos nos painéis a seguir. Então, iniciaremos com o professor Philip Baker, que, além da sua experiência e do seu conhecimento notório, participou em muito da construção do sentido dessa norma, haja vista que muitos case laws mencionam a sua doutrina. Então, teremos o privilégio de ouvir o professor Philip Baker. Sem mais delongas, passo a palavra ao professor Philip Baker. Bom dia, professor.
I don't speak any Portuguese, but I think that was an invitation for me to speak there. Let me begin by thanking the organizers of the conference, particularly Professor Caliendo and Professor Perisson de Andrade, for their very kind invitations to take part in this panel. I'm going to see whether I can just share my slides, and that should work. Let's see. There we go. Oh, that's that's the last slide. Thank you. Let's do the beginning part before I come to the thank you there. I'm going to kick off by briefly reminding us a little bit about the history of the beneficial ownership concept. A number of my colleagues are going to go into a lot more detail. Several of them have written and researched very extensively on this topic, and so I'm just going to rather gently ease us into the topic of beneficial ownership. I'm going to remind you that for much of the history of tax treaties, if we think that treaties began to appear at the end of the 19th, beginning of the 20th century, for much of that history, we lived without the beneficial ownership concept. The concept only began to appear in tax treaties in the 1960s. If you do a search, the first time that the beneficial ownership limitation is found in the dividend and interest articles is in 1966, when the UK-US treaty was amended by a protocol. Blazej reminded me that the beneficial ownership concept had appeared once or twice before the 1960s, but in the context of the beneficial owner of shares. But when one's looking at the beneficial ownership of an income stream, that is the ownership of dividends or interest or sometimes royalties, it wasn't until the 1960s that started to appear. And the first public appearance was in the UK-US treaty. Actually, if you go and look at the archives, the first discussion about using this limitation comes a couple of years earlier in negotiations between the UK and the Netherlands. In the mid-1960s, the UK and the Netherlands were having a discussion about updating their treaty, and it was the UK delegates who said, we are a little bit worried about the way that the treaty is formulated at the moment, because at the moment it simply says dividends paid to a recipient of the other country shall enjoy the reduced withholding tax. And we're worried that that means that if shares were registered in the name of a nominee or an agent, the dividends would still be paid to that person, and that person would be entitled to get the reduced withholding tax. And that would be a very, very easy way of treaty shopping and obtaining the benefit of the treaty for persons who were not entitled. We want to put in some restriction. We've tried to use a subject to tax restriction, but the subject to tax is a problem, because if, for example, a dividend is paid to a pension fund which is exempt, then it's not subject to tax. So subject to tax isn't really working. And it was in the context of the UK-Netherlands discussion that the British put forward the idea of using the term beneficial owner. And the Dutch delegates at the discussion said, we're not really certain about that, because we don't understand what beneficial owner means. We think it's all to do with trusts, and you have these funny trusts in the United Kingdom. We don't have them in the Netherlands. So the British delegates wrote an explanatory letter, which they gave to the Dutch delegates. The Dutch delegates read that and they said, oh, okay, we understand that this is all about nominees and agents, and we're prepared to accept it. So it was really the British who introduced the idea of the beneficial ownership concept in the dividend and interest and sometimes the royalties article. And it was to address the British concern that shares, debt could be registered in the name of a nominee or agent. Well, as you know, the OECD picked that up. Discussions at the OECD Working Party 1 focused on how these concerns of the British about nominees and agents could be dealt with. And the British said, well, we've used this term beneficial owner, and it came into the OECD model in 1977. And from the mid-1970s onwards, we regularly see the beneficial ownership limitation included in the dividend and the interest articles of tax treaties. It's very clear, if you look at the original commentary in 1977, that this was intended to be a very, very narrow, targeted anti-avoidance measure. It was intended to target, as it's highlighted there, where an intermediary, such as an agent or a nominee, is interposed between the beneficiary and the payer. That was the concern that the British had, and that was what was intended to deal with by putting in the beneficial ownership limitation. Problems really came to arise in the 1990s when there was a discussion that maybe the beneficial ownership concept could be more generally used as an anti-treaty shopping measure. And that particularly came out of the OECD report on conduit companies, where the idea of treaty shopping by inserting a conduit company was discussed, and the possibility that one way to deal with that would be by using this beneficial ownership concept, which wasn't originally intended to be as broad an anti-avoidance measure. So you can see that the commentary was amended in 2003. So a company that acts as a conduit for another person who receives the income, that conduit should not be regarded as the beneficial owner. So a conduit company cannot normally be regarded as the beneficial owner, if though the formal owner, it has as a practical matter very narrow powers which render it in relation to the income concerned a mere fiduciary or administrator acting on account of the interested parties. Well, if it had stopped there, again, I don't think we'd have had too much of a problem, because I think I understand what is meant by a nominee or an agent or a mere fiduciary or administrator. It's somebody who doesn't have real control over the income flow and who is receiving it and passing it on to someone else. But unfortunately, revenue authorities particularly tried to start using the beneficial ownership concept as a more general anti-treaty shopping measure. For the first 30 years or so of the beneficial ownership's life, we had very little case law. And then suddenly in the 2000s, we had a series of case law around the world where tax authorities used the beneficial ownership concept to challenge more broad treaty shopping. We had the Indo-food case in the UK, though that wasn't actually a tax authority case, but a commercial case. In Canada, you had cases like the Prevo case. And there were other cases around the world where courts had to deal with arrangements that were not clearly nominee or agency arrangements, but where the beneficial ownership concept was at issue. That caused some concern and some confusion, and the OECD tried to respond to that by amending the commentary. The first proposed changes to the commentary in 2011 were not particularly well received, but in 2012, the OECD came up with a more precise, targeted change to the commentary that was designed to ensure that, in a sense, the beneficial ownership limitation was put back into its box, that it didn't cause so much concern, and that it was really targeted in situations where there was a legal or contractual obligation on the recipient of the dividend or the interest to pay on that particular dividend receipt or interest receipt to a third party. And that was reflected in the 2014 OECD model. However, in a sense, you can try to put the genie back in the bottle by changing the commentary, but the genie is out there. And other cases have continued to raise issues about the meaning of the beneficial ownership. I'm not going to go into these, but you'll know that there's a whole series of cases in Switzerland where the Swiss court has treated beneficial ownership as a more general anti-treaty abuse provision. And it's now moved into the realm of European law, where the beneficial ownership limitation was used in some of the EU directives, the parent subsidiary directive and the interest royalties directive. And we now have the Danish beneficial ownership cases from the European Court. Given the ongoing uncertainty, which I would say still exists over the meaning of the beneficial ownership, it raises a question whether, two questions really. One, should the beneficial ownership test have ever been introduced into tax treaties? Given how unclear is its meaning, should it have ever been introduced in the first place? And I think there's a good argument that it was a mistake to introduce it in the first place. But even if you think that it was a good idea at the beginning, now that we have post-BEPS, the principal purpose test, a general anti-abuse principle imposed into all tax treaties, is it now the time to get rid of the beneficial ownership limitation completely? Should we be saying that we only really need the principal purpose test, or is it frankly too late to do that? And that, in a sense, is the question that I'm going to leave on the table. Should we get rid of beneficial ownership and simply live with the principal purpose test? Thank you very much indeed for listening to me. And now I'm delighted to pass back to Perisson, who's going to introduce the next speaker.
Muito obrigado, professor Philip Baker. Muito claro quanto ao sentido original da cláusula do beneficiário efetivo, o seu sentido buscado pela OCDE e a tentativa da OCDE em 2014 de, como o professor colocou, colocar o gênio novamente na lâmpada para esclarecer que essa cláusula não tem um significado mais amplo do que aquele para o qual originalmente foi confeccionada. Agora vamos falar com o professor Blazej, professor da Universidade de Amsterdã e um grande profissional, notoriamente conhecido, e que acabou de escrever uma obra extensa sobre o tema aqui do nosso painel, beneficiário efetivo, uma obra bastante extensa, ainda, infelizmente, não disponível em inglês, somente na sua língua materna, mas ele me avisou que em breve teremos a edição em inglês. Temos para os participantes o artigo condensando as suas conclusões, que vai fazer parte do nosso livro pós-congresso. Então, sem mais delongas, professor Blazej, a palavra é sua.
Thank you very much for inviting me for this excellent panel and very interesting never-ending story with beneficial ownership. Let me share the screen with you and show the presentation. Yes. Can you see the presentation, the slides? Yes, can you confirm?
Yes, but not in full screen yet. Not in presentation mode.
Full screen. Now should be full screen, right?
Great.
Okay, perfect. So my topic is regarding actually the most updated version of the OECD model from 2017, in particular the addition of anti-abusive elements to the model, which is the new title, new preamble, and the major anti-abusive rules mentioned by Professor Philip Baker, principal purposes test, but also a limitation on benefits. So 3 major points I would like to raise and share with you some knowledge on regard the impact of these changes on the way how beneficial ownership can be understood as of today, and in the new treaties amended by the model and also amended via the procedure available to countries under the multilateral treaty, which aim to implement swiftly BEPS changes under BEPS Action 6, prevention of treaty abuse. But before that, let's start from the very basic amendment made on to the commentary, which regards the relation between beneficial ownership and other anti-abuse rules, concepts, and doctrines. So in paragraph 12.5 of the commentary to Article 10, we can read that the provision of Article 29, which is now both principal purposes test and limitation on benefits clause, and the principles put forward in the section on improper use of the convention in the commentary on Article 1, they will apply to prevent abuses of the treaty. including treaty shopping situations where the recipient is the beneficial owner of the dividends, whilst the concept of beneficial owner deals with some forms of tax avoidance. OECD explains those involving the interposition of the recipient who is obliged to pass on the dividend, in the same vein, interest or royalties to someone else. Beneficial ownership does not deal with other cases of abuses, such as certain forms of treaty shopping, that are addressed by these provisions and principles, and must not therefore be considered as restricting in any way the application of other approaches to addressing such cases. So what we can deduce from this paragraph? First, that beneficial ownership applies earlier on than principal purposes test. This paragraph also indicates that BO, beneficial owner, applies earlier than limitation on that limitation on benefits clause, which is incorrect, because when we read limitation on benefits, we see that this clause applies just after the identification of the resident. So when we want to apply the treaty, as amended by the new commentary, new model, in line with the new model, then we first identify the resident of the contracting state. Then we need to check if we have LOB provision, whether this resident has a treaty entitlement under LOB, and then we check beneficial owner, and only then we can apply principal purposes test. So it points to the so-called order of application of these rules. But it clearly says that beneficial owner, as also follows from the origin of that concept and the historical context presented by Professor Baker, is at the most a very narrow anti-abusive concept. Following the changes to the model commentary, at OECD decided to get rid of, from the commentary, these 5 anti-conduit approaches, which were originally included in the conduit report in 1986, the so-called look-through approach, subject to tax approach, channel approach, bona fide safeguard, and limitation of benefits approach, which means that, in my perception, BO, beneficial ownership, has never meant to replace them, and with the addition of the principal purposes test, it is obvious. Why? Because suddenly, after the inclusion of the PPT to the model, the 5 anti-conduit approaches disappeared from the commentary, because it was no longer relevant to remind them at the level of commentary, since PPT is so broad that it aims to encompass all types of abusive conduit schemes. Let's now focus on the impact of the potential impact of the new title to the OECD model, and thus commentaries based on the model in respect of the interpretation of the BO concept. So the new title is as follows: Convention between State A and State B for the elimination of double taxation with respect to taxes on income and on capital, and the prevention of tax evasion and tax avoidance. So first of all, there is no link between this change in the title and the concept of BO whatsoever. Such link, on the other hand, is explicitly visible in respect of the principal purposes test and other changes to the OECD model, both in relation to LOB clause and the specific special anti-abusive provisions. Why there is no link between them? Not only because there is nothing in the commentary that would suggest that, but also because the BO clause does not have in its wording, in its structure, anti-abusive premises that could be used to prevent abusive tax avoidance. Moreover, from the interpretative point of view, the mere titles are so vague, so general, that they are too remote to have any instructive, decisive, or even significant influence on the understanding and application of the concept of the BO. So something more than the title is needed. And the question is whether the new preamble would be sufficient to change the perception of beneficial ownership and apply it now in a more anti-treaty abusive way. So the new preamble says that countries desiring to further develop their economic relationships, so it's the most important, let's say, like the ultimate general purpose of the treaty is the further development their economic relationship and to enhance their cooperation in tax matters, intending to conclude a convention for the elimination of double taxation. So still the main operative purpose of the treaties is the elimination of double taxation with respect to taxes on income and on capital, without creating opportunities for non-taxation or reduced taxation through the evasion or avoidance. And then the reference to treaty shopping is made in the brackets. So here again, there is nothing in the commentary to the OECD model from 2017, which would indicate a connection between the new preamble and the beneficial ownership concept. On the other hand, there are many explicit references to the principal purposes test. Paragraph 1 to Article 29 signifies the interpretative role of the new preamble to the principal purposes test and LOB. So in paragraph 1 of the commentary to Article 29, we can read that Article 29 reflects the intention of the contracting states incorporated in the preamble of the convention to eliminate double taxation without creating opportunities for non-taxation or reduced taxation through the evasion or avoidance, including through treaty shopping arrangements. So the role of the principal purposes test, and in some rare instances LOB clause, is to materialize the content of the preamble. This is not the role of the concept of BO, clearly. Beyond principal purposes test and LOB, the new preamble may have interpretative impact on other treaty provisions, but they are particularly included in the Article 23, methods for avoidance of double taxation. So I would say that there is no amplifying anti-abusive effect of the language of the new preamble on the concept of BO, because the preamble may to some extent clarify and help interpret and apply only principal purposes test, LOB clause, or methods for elimination of double taxation, but it could not be used to extend this anti-abusive scope, if any, of the concept of BO. Let's now look at the principal purposes test. So one of the most important and informative parts of BEPS section 6 on the principal purposes test are paragraphs 15, 19, 26, and paragraph 57, 62, 74 of the commentary to the introduction, and to Article 29.9, in particular paragraph 169 of the OECD model, from which we can read that principal purposes test targets all forms of treaty abuse. In paragraph 175 of the commentary to Article 29, paragraph 9, we can read that principal purposes test covers limitations on the taxing rights of a contracting state in respect of dividends, interest, or royalties arising in that state and paid to a resident of the other state, who is the beneficial owner, under Article 10, 11, and 12. So it is clear from the new commentary to principal purposes test that this is that rule, the PPT, rather than the concept of BO, which is the main anti-abusive and the broadest in terms of the scope among all anti-abusive clauses, specific, narrow, that could be found in tax treaties. We have also some more specific, calibrated anti-abusive rules, like the new Article 10, paragraph 2, letter A, the so-called anti-dividend stripping rule, or Article 13 and 4, 13, paragraph 4, anti-real estate circumvention rule added to the model in 2017. their main task is to support principal purposes test in effective elimination of treaty abuse. But again, there is no role of that kind attributed by the OECD to the beneficial owner in 2017. Then, when we look at the examples to the principal purposes test, paragraph found in paragraphs 176, 182, and in paragraph 187, commentary to Article 29, paragraph 9, then we can find that in some instances, namely example A in paragraph 182, the facts included by the OECD in the commentary look like summarized facts from certain cases on beneficial ownership, like the Royal Dutch Shell case, or in example B in paragraph 182, Royal Bank of Scotland case. That case, I think, will be more analyzed in the presentation of Professor Patricia soon, so I will not dive into the details. It's just to point out that suddenly the OECD used the fact patterns taken from the typical BO cases in order to clarify how principal purposes should operate. So one may conclude, based on such structuralization and wording of the examples, that even cases that were all covered by BO historically now should be covered by the principal purposes test. And OECD did not mention even a single word about beneficial ownership in these examples. The entire focus was on the principal purposes test. So I would dare to conclude that the inclusion of the principal purposes test to OECD model significantly reduces the anti-abusive scope of BO, leaving this concept now almost entirely without any role apart from triggering expensive and resource-consuming litigation. Actually, the only role that it may have right now is to eliminate agents and nominees from the scope of application of Articles 10, 11, and 12 OECD model. And finally, LOB clause, to soon conclude, and its impact on the BO. So the LOB is very, very extensive and complex anti-conduit rule based on the US style clause included in the US in its model from 1980s up until today. It effectively raised the entry point, the threshold, which is entry point to the tax treaties. So it works completely different than the principal purposes test. It's not about denying the benefits, it's about denying even being considered as an entity, a person that is entitled to treaty as such. So beneficial ownership concept in the treaty where the LOB is included may apply only to a person which is a resident, of course, and is a resident entitled to treaty benefits under LOB, the so-called qualified person or qualified resident. So such entities normally will have a strong nexus with its country of residence, strong enough to qualify to treaty benefits under LOB clause. So even if such entity in a very rare and narrow scenarios could be engaged in abusive treaty shopping, it is rather the role of the principal purposes test to strike down such abusive transactions and scheme rather than the role of beneficial ownership. So to conclude, in my opinion, I think that the changes to the OECD commentary and the model in 2017 significantly diminish any anti-abusive role and scope of the beneficial ownership concept. One may only wonder whether OECD realized that the BO concept is inadequate to target treaty abusive situations, because it was never, of course, admitted by the OECD. It would be like admitting to making mistake for decades. And one may even dare to say that nowadays, with the principal purposes test and LOB clause, the concept of BO has become entirely obsolete and therefore also redundant. And the best would be to simply get rid of this concept from the model and all tax treaties. But it is highly unlikely that it will happen, not only because the OECD in such a scenario will need to admit to own mistakes made in 1977 to follow the British delegation and include the concept of BO to the treaties, but also, as we all know, now the agenda of the OECD is fulfilled with implementation of Pillar 2 and Pillar 1. So with that, I would like to thank you very much and pass the voice again to Perisson.
Ok, professor, muito obrigado pela sua explicação claríssima, muito aprofundado o exame da questão, nos colocando aí bastante food for thought, né? E uma proposta muito interessante, né, de a OCDE reconhecer os seus equívocos, tá? Está na hora dela começar a reconhecer alguns equívocos. Um deles é o beneficiário efetivo, e a sua proposta de revogação integral realmente me agradou bastante, embora, como o senhor disse, realmente é, como os ingleses dizem, wishful thinking, né? Dificilmente a OCDE procederá dessa forma. Bom, agora vamos conversar com o professor João Felix Nogueira, professor da Universidade Católica Portuguesa, Universidade de Amsterdã, profissional conhecidíssimo, renomado, e sobre o assunto que ele falará, gostaria de chamar a atenção de uma opinion statement, escrita aí pelo professor João em 2019, acerca de diversos case laws da Europa, em especial casos de Luxemburgo e da Dinamarca, relativos ao beneficial ownership, uma opinião que eu recomendo fortemente a leitura a todos. E, professor João, a palavra é sua.
Muito obrigado e um bom dia a todos, boa tarde a quem nos vê deste lado do oceano. Gostaria de começar por felicitar os professores Choeiro e Neto e Meite pela organização do Congresso e o professor Perisson Andrade pela coordenação, o professor Paulo Caliendo pela presidência do mesmo. É para mim um prazer estar aqui convosco neste dia a discutir sobre este interessante tema. Devo começar por dizer que a minha apresentação será algo controversa. O tema que irei tratar, ou o modo como irei tratar este tema, assemelha-se com o roteiro do filme Minority Report. Nesse filme, temos a brigada do pre-crime que procedia à detenção de criminosos antes do crime ser cometido, baseado numa antecipação de futuro que era feita por estes precogs. Se se lembram, o Tom Cruise era o chefe da brigada e o Colin Farrell era o agente do Departamento de Justiça. E, da mesma forma como nesse filme se tentava evitar o crime antes que ele acontecesse, o que nos vamos dedicar nos próximos minutos é saber se podemos detectar o beneficiário efetivo antes do pagamento da renda acontecer. E, portanto, é possível prever e antecipar os casos de beneficiário efetivo? Será que podemos desconsiderar a personalidade jurídica de uma sociedade intermédia antes mesmo de ela intermediar a transação? Será que podemos condicionar a aplicação da cláusula ou antecipar a aplicação da cláusula através de BO precogs, de precogs de beneficiário efetivo? E se sim, o que seriam esses BO precogs? Requisitos de substância, decision trees, especialmente desenhados para o efeito. Este será o foco da minha apresentação. Antes mesmo, importa voltar de novo a esta distinção entre duas figuras que, sendo próximas e complementares, não são coincidentes: beneficiário efetivo e abuso. Notem que ambas podem levar e levam à desconsideração da personalidade jurídica de uma sociedade intermédia. No entanto, fazem-no através de operadores e de critérios diferentes. O beneficiário efetivo é uma cláusula relativa à atribuição de rendimento, à attribution of income, e pretende determinar quem é que verdadeiramente flui de uma dada renda. Para o beneficiário efetivo, partimos do pressuposto que tanto a entidade como a transação existem, e é apenas uma questão de saber se a entidade intermédia frui do rendimento. Para tal, seguimos os critérios previstos nos parágrafos 12 e seguintes do comentário ao artigo 10 da Convenção Modelo da OCDE, que os meus colegas Blazej e Felix acabaram de mencionar. Ora, uma questão lógica e cronologicamente anterior, ainda que na Convenção Modelo apareça como posterior, e o professor Blazej esteve a falar sobre esta discrepância, é saber se existe abuso, se a sociedade que intermedia numa operação existe ou não. E os critérios para a sua determinação são, nos termos da Convenção Modelo da OCDE de 2017, diferentes. Encontram-se previstos no artigo 29, número 9, da Convenção Modelo da OCDE para a generalidade dos países, números anteriores do artigo 29 para, essencialmente, os Estados Unidos. Nota que esta distinção entre abuso e beneficiário efetivo, que é fácil na teoria, na prática não é assim tão simples. Número 1, ambos podem levar à desconsideração da personalidade jurídica. Número 2, doutrina, praxis administrativa e jurisprudência tentam usar um para prosseguir os efeitos do outro e vice-versa. E 3, o conceito, como já viram nas apresentações anteriores, o conceito de beneficiário efetivo, no quadro da Convenção Modelo da OCDE entre 2003 e 2014, tinha um recorte antiabusivo. E devo salientar uma coisa que ainda não foi referida agora. Se vocês atentarem no fraseado do parágrafo 12.5 da Convenção Modelo da OCDE, a versão mais atual, ele ainda refere: whilst the concept of beneficial owner deals with some forms of tax avoidance, enquanto que o conceito de beneficiário efetivo lida com alguns temas de tax avoidance, ou seja, a clarificação não foi assim tão clara, e nos próprios comentários à Convenção Modelo da OCDE continuamos a ver uma associação clara, literal, específica e explícita entre beneficiário efetivo e avoidance, que eventualmente não deveria acontecer se pensarmos na cláusula como ela foi originalmente pensada, como nos descreveu o professor Felix. Bom, mas vamos assumir que a cláusula é clara, que há uma clara separação entre abuso de um lado e beneficiário efetivo do outro. Por que é que ainda se confundem as noções? Eu penso que consegui identificar as 6, 7 razões pelas quais existe esta confusão e passarei na minha apresentação a referi-las. E peço desculpa por me ter esquecido de um dos slides. Portanto, quais as razões que levam doutrina, jurisprudência e administrações tributárias a ainda confundir? E quais as razões pelas quais, em minha opinião, isto ainda vai continuar a acontecer por muitos e longos anos, exceto se alguma mudança for feita no próprio texto da Convenção Modelo? Portanto, repetindo, quais são as razões pelas quais, em minha opinião, o conceito de beneficiário efetivo continuará a ser confundido com o de abuso? Número 1, porque estas mudanças todas deram-se ao nível dos comentários, o que suscita sempre dúvidas sobre o caráter vinculativo dos mesmos, as quais somam, soma-se as questões de saber se as alterações de 2003, 2014 e 2017 são clarificações ou em que medida em que algumas partes podem ser consideradas clarificações. Depois temos ainda o facto de a interpretação literal das duas expressões não coincide, nas versões oficiais da Convenção Modelo da OCDE, nas duas línguas que fazem fé, não coincidem integralmente. Em inglês, beneficial ownership, que nos remete para algo com propriedade, e em francês, beneficiário efetivo, do qual traduzimos para o português, beneficiário efetivo, que parece lidar-se com alguma coisa mais de substância sobre a forma. Notem que ambas as línguas, como referi, são línguas autênticas da Convenção Modelo. Número 2. Como vimos, entre 2003 e 2014, temos comentários que nos remetem para uma noção antiabusiva. E, portanto, se fizermos uma interpretação estática de comentários, estática de tratados desenhados à luz daqueles comentários, temos inevitavelmente, ou é legítimo fazer uma interpretação da cláusula com caráter antiabusivo, e estes tratados vão continuar por muito tempo. Nem o MLI corrige isto. Número 3. Mesmo nos tratados pré-2003 e pós-2014, na ausência de uma cláusula geral, e notem que o MLI ainda não entrou em vigor em todos os tratados bilaterais, na ausência de uma cláusula geral, a cláusula do beneficiário efetivo é que mais se assemelha a uma cláusula geral. Portanto, é aquela que as autoridades tributárias vão recorrer, legítimo ou ilegitimamente, para um combate legítimo do abuso. Ou seja, as autoridades tributárias veem-se face a uma situação de abuso, necessitam de um qualquer apoio literal, gramatical no texto das convenções e recorrem e continuarão a fazer ao texto ou à cláusula do beneficiário efetivo, que, apesar de tudo, são duas palavras. Quarto motivo. Porque em alguns países, claramente em Espanha, parcialmente em Portugal, o recurso a uma cláusula geral depende de um procedimento prévio próprio. Enquanto que a cláusula recurso a uma comissão, uma pré-autorização dentro da autoridade tributária, enquanto que a cláusula de beneficiário efetivo não o exige. Quinta razão. Porque a cláusula geral anti-abuso é muito mais difícil de aplicar, requer a verificação de muitos mais requisitos do que a cláusula de beneficiário efetivo, que depende apenas de duas palavras e poucos comentários que não condicionam fortemente a sua atuação. Número 6, porque ainda existe, porque criou-se aqui um problema de, diria, osmose linguística, criada pelos casos dinamarqueses do beneficiário efetivo. Qual é o problema? Temos estes casos célebres de 2019, em que o Tribunal de Justiça decide casos situados na Dinamarca em que tínhamos sociedades intermédias e em que os tribunais e a administração tributária local questionam se eles eram ou não beneficiário efetivo. No entanto, e ao contrário do que o nome dos casos, ou que o nome conhecido dos casos, Danish Beneficial Ownership Cases, os casos não foram decididos com base no critério do beneficiário efetivo. Os casos foram decididos com base no que o Tribunal de Justiça da União Europeia classifica princípio geral não escrito de proibição de práticas abusivas. Ou seja, nós temos casos que não são decididos com base nos critérios, em regras de beneficiário efetivo, são decididos com base num princípio geral de direito da União Europeia e que os tribunais estão a recorrer para aplicar a cláusula convencional do beneficiário efetivo, simplesmente porque se generalizou na doutrina o nome Danish Beneficial Ownership Cases. É estranho, mas os tribunais encontram legitimidade de aplicar os indícios dos Danish Beneficial Ownership Cases que não têm a ver com a aplicação do beneficiário efetivo a situações convencionais de tratados que têm a ver com o beneficiário efetivo. Sétimo e por último, porque os tribunais, quando têm de aplicar uma cláusula, vão à procura de doutrina e especialmente de jurisprudência sobre essa mesma cláusula. E a generalidade da jurisprudência que vão encontrar, seja referida a tratados pós-2003, seja mesmo referida a tratados anteriores, aplica esta cláusula com um caráter algo antiabusivo, seja esta de uma substance over form, economic substance, seja forma de um business purpose. Existem várias modalidades de aplicação da cláusula do beneficiário efetivo com um caráter marcadamente antiabuso. É este ainda o sentido que prevalece na jurisprudência, e um juiz, mesmo que tributário, provavelmente não tem a sensibilidade de perceber se aquilo se refere a uma ou outra versão dos comentários, se refere a uma leitura correta ou incorreta dos comentários à Convenção Modelo da OCDE. Portanto, feita esta distinção e posta a explicação de porquê que a cláusula de beneficiário efetivo, em minha opinião, vai continuar a ser aplicada com sentido anti-abuso, cumpre responder à questão do início, que é saber se nós podemos desenhar precogs, se podemos antecipar a aplicação da cláusula anti-abuso antes que a cláusula de beneficiário efetivo, antes de uma qualquer transação. E em nossa opinião, a resposta é claramente sim. Nada impede que se recorra à legislação existente, que se densifique com a doutrina e com a jurisprudência existente e se transforme a linguagem eventualmente difusa e confusa em linguagem binária, em linguagem sim ou não. Esta tendência de mecanização da aplicação de direito existe em vários setores e também fará a sua entrada no direito tributário internacional. Eu, pelo menos, conheço 3 grupos de investigação que se dedicam à transformação da linguagem PPT em linguagem binária. E até penso que o professor Blazej participa de um deles. Portanto, posta esta primeira questão, sim, é possível criar precogs, sim, é possível criar decision trees que nos permitam determinar como é que as vamos desenhar, porque é essa a questão mais importante. E aqui tudo depende. Vamos desenhar estes precogs como um abuse-oriented beneficial ownership, como critérios dirigidos a uma aplicação de recorte abusivo, ou vamos desenhar estes precogs com uma interpretação típica da convenção, do resultado da Convenção Modelo 2014. Não é 204, como está nos slides, mas 2014. Se nós fizermos com o recorte abusivo, nós vamos recorrer a critérios que se assemelham em todos aos que estão no comentário ao artigo 29, e vamos ter aqui uma redundância. Mas podemos fazê-lo, ou podemos recorrer aos critérios que neste momento estão a ser discutidos ao abrigo da iniciativa Unshell no quadro da União Europeia. Então podemos verificar qual é o montante de renda recebida e paga pela empresa, quem é que efetivamente controla a empresa, quais os edifícios, os equipamentos e o staff da empresa, a posse, o uso, o risco e o controlo, possession, use, risk and control, e os critérios, por exemplo, derivados dos Danish Beneficial Ownership Cases. Qual o resultado? Se nós aplicarmos estes critérios, se aplicarmos a Unshell ou aplicarmos uma linguagem binária retirada do artigo 29, nós vamos ter uma repetição de 29. Não faz sentido, aparentemente. Portanto, em minha opinião, o modo de superar este problema que eu assinalei, aquelas 7 razões pelas quais o beneficiário efetivo vai ser aplicado de modo errado, seria densificar, concretizar a cláusula de beneficiário efetivo em questões muito concretas, que, em minha opinião, se resume a estas. E estou aberto, obviamente, à discussão. E por isso é que disse que a minha apresentação seria algo controversa. Estas questões equivalem às interrogações que correspondem à aplicação própria da cláusula do beneficiário efetivo, que não se confunde com a cláusula do PPT. E a primeira pergunta de um formulário, a primeira pergunta que um perico ia avaliar é: quando se recebe renda, porque o beneficiário efetivo é o beneficiário efetivo de renda, quando recebes renda, estás a atuar em teu nome e por tua conta ou por conta de alguma outra pessoa? És um agente, nominee ou fiduciário, ou representante. Número 2, a renda que recebes obriga-te a pagá-la a alguém? Há um predetermined flow of funds? Isso sim, mesmo que não seja a mesma porcentagem, pode ser 10% acima, 10% abaixo, mesmo que não seja no mesmo ano fiscal, mesmo que seja condicionado a um outro evento certo ou incerto. Portanto, isto seria um questionário que a própria empresa teria de verificar. E em terceiro lugar, se decidires não pagar essa renda a um terceiro, será que violas uma obrigação contratual ou legal? Em meu entender, tudo o que vá para além disto e que entre mais em questões da substância são questões legítimas no quadro dos tratados, mas são questões que não devem ser tratadas pela cláusula do beneficiário efetivo, mas devem ser tratados pelo artigo 29 das convenções bilaterais, ou da cláusula PPT, desenhada em torno do artigo 29 da Convenção Mundial da OCDE, ou, na sua ausência, através de uma aplicação de uma cláusula doméstica, a qual é passível de aplicação recorrendo ao Guiding Principle da OCDE. Portanto, sintetizando, concordo com Philip Baker, a aplicação reduz drasticamente. Concordo com o Blazej que eventualmente tem um significado totalmente diferente. Para mim faz sentido, deve continuar. Os casos de agente, nominee, fiduciário, não devem beneficiar dos benefícios, desculpem a repetição, não devem beneficiar dos benefícios da Convenção. No entanto, tudo o que se prenda com a artificialidade, tudo o que se prenda com a questão da substância sob a forma numa transação, para além destas perguntas, não pertencem à cláusula do beneficiário efetivo, mas sim pertencem à cláusula antiabuso. Muito obrigado pela vossa atenção, many thanks for your attention, e estarei disponível para perguntas no espaço da Q&A. Passo a palavra ao professor Perisson de Andrade.
Obrigado, professor, pela exposição. Um ponto de vista controverso, mas realmente muito racional, reduzir uma previsão somente com 2 palavras a uma previsão mais lógica, com algumas dicções a mais, binária, como o senhor bem colocou, resolveria com certeza essa questão. E também a delimitação específica, aquelas situações de identificação do efetivo beneficiário de acordo com o controle que se tem sobre a renda recebida, deixando artificialidade, substâncias, essas questões para a PPT, com certeza seria uma boa proposta. Infelizmente, o que a gente observa é que as autoridades fiscais acabam misturando tudo, alhos com bugalhos, procurando fundamentar a sua atuação o mais completamente, integralmente possível, de forma legítima, aliás, mas muitas vezes fazendo essa confusão entre os institutos, né? Agora, passo a palavra para a professora Patricia A, professora emérita de Direito Tributário, muitos anos pela Universidade de Miami, atualmente, exclusivamente nas Nações Unidas, fazendo todo um trabalho que nós, com certeza, devemos prestar atenção, que certamente vai influenciar os comentários no modelo das Nações Unidas, vem trazer aqui um aspecto muito particular, muito interessante, que é beneficial owner no contexto das transferências com a utilização de instrumentos híbridos. Aí a coisa realmente fica mais complicada ainda e ela vai, com certeza, nos esclarecer esse ponto. Professora Patricia, a palavra é sua, eu vou passar suas apresentações.
Thank you very much. It is a pleasure to be with you all again. As Professor Perisson just described, I have moved since the last time I spoke to you. And in my capacity now at the United Nations, I have moved from teaching students how to game the system to teaching, helping developing countries in addressing these concerns. So I think what we've heard from the other panelists is very helpful to clarify how these different provisions apply and the types of transactions they apply to. But I think before we, and I think ultimately the answer is because as principal purpose tests are added, the beneficial ownership as a concept will shrink to the nominee and agent universe that it effectively applied to at the beginning. But I think we have to keep in mind that the principal purpose test probably isn't about half of tax treaties right now. A news release from the OECD says that the MLI, as of the beginning of May, will apply to 880 treaties. So it is, when you add the other treaties that don't get the principal purpose test through the MLI, it's probably still less than 1,500 or so at the moment. And so beneficial ownership still has, I think, some lasting importance for a lot of the countries that I deal with. So, and thank you for the slides. I want to start with looking at this slightly differently, and I'll tell the story of why that is. In 2005, when I was at the Treasury Department, I had a government official from another tax authority wanted to come in and talk to me about the new transaction they were starting to see. And I said, fine, and we sat down and I looked at his slides. He had a diagram of the transaction, and I realized that the transaction he was showing me in 2005 was one that I had first seen in 1988. And so part of the problem is that, and what I'm trying to show with this presentation, is that there are certain techniques that get dressed up slightly differently in different countries in order to achieve arbitrage results, but they're really the same transaction. So if we go back to the first slide on what is a hybrid transfer. So a hybrid transfer effectively is when two different countries take different views about who is the beneficial owner, or simply the owner of an asset or income flows. And the desired result, and this is all set out in the BEPS Action 2 report, the desired result is at least deduction no income, because one country views the transaction as debt and the other country views it in accordance with its form. And I've talked about this in a binary or bilateral situation, but there may be three countries involved at least, and you may actually get a result that is DD-NI, depending on the circumstance. The desired benefit for the dividends for that no income is actually not always no income. It could be a participation exemption, it could be a foreign tax credit, it could be imputation benefits, or it could be some other exclusion. And all of those show up in just the 4 transactions that I've chosen to highlight in this presentation. And these are all 4 transactions that I knew off the top of my head. My guess is that there are probably a number of different variations on these transactions. The recommendation in the BEPS Action 2 report is to deny deductions, or if not, then deny the benefits relating to the dividends. And it's worth noting, these generally are not treaty-based remedies, but in at least a couple of cases they are. So if we could go to the next slide. I'm not going to take you through all the slides because they're pretty repetitious, but I will go through the first one, which is the example that's in the BEPS Action 2 final report. And this is a repo. They describe it as a repo. And in this transaction, country A has a subsidiary in the same state. It transfers shares of that country A sub to country B, and at the same time enters into a transaction, a repurchase agreement to purchase back those shares at sometime in the future at a price certain. And that's what makes it a repo. It's a debt instrument because the country B company knows that at the end it will get back the amount that it originally gave to country A. So it has that certainty. So if we go to the next slide, during the course of the transaction, the desired country A view of these payment flows is interest going to the country B co. In the case of the usufruct transaction, it's principal and interest because there's no corresponding return at the end. But essentially the point is that country A says, this is just a loan, and country A is paying interest and receives an interest deduction. It's also important to note that probably country A, when the parent company and the subsidiary are in the same jurisdiction, they will probably consolidate. This slide is the other side. What is the desired country B view? And that is dividends flowing directly from the country A sub to the country B sub that will either qualify for the participation exemption, sometimes a foreign tax credit, or sometimes something else. And then if we go to the next slide, at the maturity of the transaction, usually there will be a reversal of the original transaction, which is what gets the money back to country B and the shares back to country A. Although, again, country A always thought that those shares always belong to country A. So that's the example in the final report. If we go to the next slide, where are we? Yeah, the next slide is Bank of Scotland. Again, I'm not going to, it's the same transaction. The only difference here is instead of a sale repurchase transaction, there was a usufruct over the shares of the French subsidiary. And if you go to the next slide, the point of the Bank of Scotland case, again, this is the US is going to treat it as a debt instrument. And if you go to the next slide, this is where the benefit came from. And this was actually a treaty benefit. It was under the UK-France tax treaty. Under Article 9 of that treaty, the UK gave the benefits of its imputation system to French resident companies. France did the same with respect to UK resident companies. And so there was an actual cash payment from the French Treasury that went along with those dividends. So that's not a DNI result. That's even better than that. And if you go to the next slide, there are a couple points here, right? There's no return of the shares, so it looks a little bit different from the Action 2 report. but there were other agreements guaranteeing the repayment. There was a question. It was answered in at least one article that I saw that suggests that the usufruct itself was amortizable, which meant that the US company would have gotten a deduction. Possibly the UK Bank of Scotland was able to amortize the purchase price of the usufruct over the life of the usufruct, and there was that cash payment. Now, the avoir fiscal was denied. There was a lot of discussion of beneficial ownership. There was also discussion of anti-abuse. So there's a lot of back and forth and academic wrangling over exactly what the Bank of Scotland case means. And my point is that saying that it's beneficial ownership would be a mistake. And in these transactions, giving certainty that it's beneficial owner would be a mistake. Because if we go to the next slide, what would happen if in fact, now I know France is a civil law country, and so case law doesn't mean the same it does in common law countries. But if you actually say that that transaction is a debt instrument, then an investment banker or international tax planner would look at it and say, okay, now I have certainty that France will treat this as debt. So where can I do this transaction next? What country? I'm just going to put France in there in the same place that the US company used to be. I might use a French sub if I can do a usufruct over the shares of a French sub. I might find some other a sub in some other country. And so as a planner, I would just start looking for new bilateral pairs once I have that certainty, which is why beneficial owner is not the way I would attack this. Because of course, the reason that practitioners are comfortable putting a US company into these transactions is because they're relying on an old revenue ruling about share repurchase transactions that treat it as debt. So they feel they have that certainty. Which brings us to a chief counsel advice that came out in 2006. Here, it may look a little bit different because the preference share and the money are at a different level, but in fact, it's exactly the same transaction because the US co and the US sub are part of a consolidated group. And so the interest deduction at the US sub level offsets the income of US co. Here, they're putting call options between US co and country B, which are the way that it is guaranteed that B co will get its money back. So I think the next three slides are essentially the same. So if we can go past this one and this one, here, again, it reverses when the money goes back to country B at the end and the preference share goes back to US, is redeemed and goes back to US sub. But if we can go to the next one, here the desired benefit for the dividends was a foreign tax credit. So there was still no taxation because it was exempted. In this case, the IRS denied the interest deduction and the benefit of the zero withholding rate on interest by applying its domestic reverse hybrid rules. And if we can go to Westpac, we can go to the next slide. Same transaction in this case. Actually, if we can go a couple slides ahead. In this case, the New Zealand has a special tax regime that essentially allows foreign sourced income to flow through. without being subject to tax, and that's the conduit tax relief rules, and that's what we created the exemption. And there were a couple of different cases in New Zealand. Now, what's interesting, another point I want to make, if we can go to the last slide, because I don't want to steal any more time from Jennifer. Let's go just to the last slide. You can all look at these slides and see how they're the same, right? The point, the takeaway slide. So what do I want people to keep in mind here? And that is, there are many different ways to create a debt obligation. Redeemable preference shares, repos, there were a couple others thrown in there. The desired benefit for dividends may take very different forms. So when tax authorities are looking at this, I don't want them to get caught up saying, well, this is, I'm looking for a repo transaction. Tax authorities have to think about what is really going on, to think like investment bankers and say, okay, the pattern is a split, something that guarantees the amount will be paid back, and something that results in the dividend not being taxed. And then if you are looking at one of these transactions, look at additional benefits that improve on deduction no income, which may be amortization deductions or additional fees. So you need to look at all the documents to really understand what's going on. And fundamentally, the point is that beneficial ownership is not a good way to attack these transactions, because using beneficial ownership provides certainty to the tax planners to develop new arbitrage transactions. So using general anti-abuse rules or specific anti-abuse rules to either deny deductions to the country A company, or to deny the dividend benefits with respect to the country B company is a much better way to attack these transactions than providing certainty. So tying back to our second presentation today, it's very striking to me that the OECD, and of course the UN, because we adopted the commentary as well, goes after the Bank of Scotland transaction under the principal purpose test, not beneficial ownership. And I think that's exactly the right way to do that. So I will turn it back. And I'm happy to answer any questions, of course. So thank you again.
Obrigado, professora Patricia, pelos seus ensinamentos, pela visão que compartilhou conosco. Realmente muito, muito interessante a abordagem do ponto de vista do beneficiário efetivo em relação a essas transações envolvendo instrumentos híbridos, que são o grande issue do direito tributário internacional, porque as operações são cada vez mais complexas, é mais complexa a legislação, as operações se tornam mais complexas também, e também compartilhando essa visão, que é, acho que geral, da maioria ou de todos os palestrantes até agora, no sentido de que beneficiário efetivo deve ter um entendimento limitado às situações nele previstos, e as situações de substância, artificialidade, devem ser tratadas pela norma PPT. Não tem mais sentido misturar os dois institutos desde que a PPT foi instaurada e tem sido implementada de forma ampla. Agora, sem mais delongas, vamos apresentar nossa última, mas não menos importante, palestrante, professora Jennifer Roeleveld, da Universidade da Cidade do Cabo, também presidente da Associação Fiscal Internacional da África do Sul e profissional notória como nós todos conhecemos, vem aqui trazer a visão particular da África do Sul, que, como todos sabemos, é um país integrante do BRICS, como o Brasil, então daí o interesse, a importância das suas observações, porque certamente muito delas nós podemos aproveitar como também país em desenvolvimento e captador de investimento estrangeiro. Professora Jennifer, a palavra é sua. It's your floor, Professor Jennifer. We are seeing you.
I just am struggling here a little bit to get back to my Zoom. Oh dear.
Do you need I pass your slides for you?
I'm just, can you see them on the screen or not?
Not yet.
I'm just struggling to share my screen. I can see my slides and I can see myself. Can you see me?
If you can see yourself, there is a, when you hover your image, there will be a green arrow. Click on that one when you hover your image, because it should be minimized.
Okay, there we go.
Yeah.
Thank you. Thank you for this opportunity to be on this panel. And I'm now going to share my slides. Here we are, and I must have a slideshow.
Great.
All right. Does that look okay?
You could put in a presentation mode, please, full screen.
Better?
Great. Perfect.
Okay.
Thank you.
Thank you. Thank you all. I just want to say that, you know, it's very difficult after hearing all these arguments that all of them are plausible and sound reasonable. And in my presentation will be a little bit different. I just want to remind everybody of how we got to where we are. I'm not going to repeat the history because that's already been done, especially by Philip Baker and Blazej. And so I just want to fill in some gaps. And if we look at the beneficial ownership term, it is probably the most well-known undefined concept that we have in our tax law. And I'm wondering, after these discussions, if in the future, the PPT is going to take its place as the number one undefined term, and we're going to struggle just as much with the PPT definition. What is known is that it seems that we all have a reasonable idea of what beneficial ownership actually means. And we have to ask, and it has been asked, is it a factual or economic substance test or a legal test? And this differs between common law states and civil law states. And as you know, South Africa is a combination of both. And if we remind ourselves of the commentary in Article 12, which uses the term, the commentary says it's not to be used in a narrow technical sense as in trust law. And Philip Baker alluded to that, and there it has a strong meaning, but it's not something we can use for tax law. And we should rather understand it in its context. Now, having said that, I just want to mention what some authors along the way have said, and this is why this makes it so difficult for us. If we look at Charles de Toy in 2021, he said, why don't we just use another term? And such as, for example, an owner, beneficial entitlement, And he suggests that if we want to keep the beneficial ownership definition, we could look at something like a person whose ownership's attributes outweigh everybody else's. That is a suggestion. If we look at John Avery Jones in 2006, his view was we never should have been incorporated this in our treaties in the first place. Robert Denon, much later in 2020, feels that because of the PPT, we should get rid of the beneficial ownership term because the PPT is capable of addressing the conduit company more holistically. And I think there's an inclination from the panel members that I've been hearing towards this view. Johan Hutting in 2019 has stated, and it is true, that common law countries will not find any clarity in their case law. So there is case law, but it actually doesn't give us a certain definition and a defined term. And Martin Jimenez refers to the beneficial ownership history as being unfortunate. So this term has really suffered over the years of perhaps not being successful in the background. And then Richard Van in 2012 said that the sole purpose of the term is the exclusion of custodians and persons in a similar situation from treaty protection in their own right. So we could just refer or include the exclusion without using the term. So that would exclude your agents and your conduit kind of situation. And if you bring that in with the definition or with the terminology beneficial ownership, I think that is how it has been solved in the past. So in the past, I think there's always been a way around it. So it hasn't become such a crucial thing that we have to actually have a proper definition. For South Africa, and we are part of this little journey that I'm talking about, it appears in Articles 10, 11, and 12 of most of South Africa's DTAs, and we have quite a lot of them, and they're based on the OECD model. It also appears in some technical fees articles, and you will see those on your screen there. And those aren't all that recent, those treaties, and some specific reason why that it was included in the technical fees article. It also appears in a protocol with between South Africa and Switzerland in 2009, which concerned getting tax credits in respect of secondary tax on companies, which was the type of dividends tax that South Africa had in the past, where the company paid the dividend, not the shareholder. So one understands that in this particular case, there was a particular problem. It also appears in an inheritance tax treaty, which we have very few of, between the South Africa and the United States. And that appears in Article 3.2, which deals with shares. And obviously it is looking at the ownership of shares of a deceased person. It is mentioned in the Income Tax Act in South Africa, but there's no actual definition. It's also in the Financial Intelligence Center Act, and it also appears in the Companies Act, which deals with corporates. So, legal ownership in South Africa, if we look a bit further, there's no legal definition under South African law. There is some derivation from case law, and ownership can be described as a legal relationship, which implies that there's a legal relationship exists between the owner and a thing, the object, and the owner acquires some entitlements, or the relationship between the owner and other legal subjects, whereby they are required that those subjects respect his or her entitlement through the object. And then it defines the relationship, what that means. The Companies Act defines when a person controls a juristic person or business. And it does that in the sense of saying that subsidiaries or related parties who act together, where they have a majority voting right or influence. So there it deals partly with beneficial ownership. Then there's no definition per se, but it does have an allusion to the notion of beneficial interest in the Companies Act. And it says beneficial interest, when used in relation to a company's securities, means or entitlement of a person through ownership, agreement, relationship alone or together with another person to receive or participate in any distribution in respect of the company's securities. So, and it goes further to say where they can also dispose or direct the disposition of the company's securities or any part of those securities, or take part or cause to be exercised any or all of the rights in respect of the company's securities, for example, as far as dividends are concerned. So there is sort of an allusion to the beneficial ownership in the Companies Act. In the Financial Intelligence Center Act, there has been an amendment proposed in 2022. And I'll find my place here. And they've introduced, the proposal is this, the wording is as follows: the beneficial owner in respect of a legal person means a natural person who either independently or together with another person, directly or indirectly owns the legal person or exercises effective control of the legal person. That is proposed, so we will have to see the outcome of that in the future. There is also a beneficial ownership reference on the Johannesburg Stock Exchange, where listing requirements are necessary for any company wishing to list on the stock exchange. And it talks about beneficial owner in relation to a security, means the person or entity who has the de facto right or entitlement to receive any dividend, interest, or other income payable in respect of that security, or the de facto right or entitlement to exercise a cause to be exercised ordinary course of events, any or all of the voting, conversion, or other rights attached to such security, and the de facto right or entitlement to dispose any part of the company's securities or a distribution, for example, a dividend. So while this doesn't influence our tax law, it is used for reporting purposes, and we could say it's a good starting point if we're beginning to look at where beneficial ownership exists, and we could do that. Just to say that in terms of the JSE and in terms of company law in South Africa, all of these organizations require quite onerous reporting responsibilities. And I know it was mentioned earlier about with the PPT, with onus and what the documentation, etc., that will have to be kept. This has already been done in respect of these kinds of requirements. And it's quite onerous, and they look at, for example, the identity of the owner. They require, if there's beneficial owner, there's a conduit, they require further information. So a lot of this information is already out there. Another place where this comes out is in the Financial Action Task Force in connection with tax evasion and money laundering, and the Global Forum, as we know. In this respect, only natural persons can be beneficial owners. So you need to go to the top of the structure to determine who owns assets at the bottom. In common law countries like South Africa, the bottom entity can also be a beneficial owner. So it is not the same in all countries. And I think this is what has been alluded to earlier, as that we have different understandings in respect of beneficial ownership. As far as FATCA is concerned and the common reporting standards, the beneficial ownership terminology is used quite widely. However, it focuses more on the income as opposed to the underlying assets. So there again, you will find where this thing diverges is looking at the assets and ownership and looking rather at the income. And I think this is why this term beneficial ownership is so elusive for us. So if we look at some case law, and I'm just going to give you a little summary of case law in South Africa, where there were some outcomes, and you will see that it is not all that helpful. So if we look at the top there, beneficial owner of the shares and a beneficial interest in shares, for example, the dividend rights, those two are not the same. And interest in shares, for example, could mean that you're not the owner, but you actually have a right to the distributions. So it is not easy to get to the bottom of the story. And beneficial owner is the direct recipient, unless such recipient is an agent or is under legal obligation to transfer the amount to another person. That is another outcome in case law. Another answer was the beneficial owner is the real owner, whatever that might mean to us in different countries. Now, in the commentaries is that the prescription towards an international meaning and not a domestic meaning, this is implied and actually is stated in the Constitution in South Africa. So courts would have to apply an international meaning as opposed to a domestic meaning. And if we remember the commentaries, it says regard must be had to the international law position, take foreign case law into account. However, South Africa is not obliged to follow the commentaries. So that kind of argument can be used whenever it's necessary or it suits the powers that be at the time. And I must say it is doubtful whether the company law definition can be used as a domestic meaning in terms of the general Renroy clause. So you can't use the definition in another domestic act in respect of tax law. And if we look at Prevost, which was mentioned by Philip Baker as well, it said that a right balance has to be struck between the ordinary meaning and the context and the purpose elements. And that equates with the Vienna Convention, where equal importance has to be given to the literal meaning of the words and the context and the purpose. And so the outcome of this, and this little summary which deals with some case law outcomes, is that we've realized that there's no shared meaning between common law countries. And I think this is why that common law countries' interpretation is dismissed by certain experts, and as there's no agreed definition between the common law countries. So this just illustrates and probably is one of the most serious reasons why we're not going to be able to give a proper definition of beneficial ownership. To go further, if we look at, if there is given an economic meaning to beneficial ownership, do you look at economic substance of the direct recipient? Do you look at control over the ultimate recipient over the direct recipient? Or do you have to look at the ultimate recipient in relation to the transaction? And what was the sole purpose of inserting a direct recipient? Was that to acquire treaty benefits? And we've heard that mentioned already. So if we took an economic meaning as such, could you say that the context and purpose would override the ordinary meaning? And I think we would all say that's not likely. That's not likely to happen. And I think in South Africa, the legal approach is the more likely one that will be adopted in South Africa. And it's probably the easier way to go. So if we look at where we are, and for those proponents that have said we need to get rid of the term, there are alternatives. And the application of the GAR, and we know that this GAR has not been applied frequently. We have, I think, only one recent case on GAR since its inception many years ago. So it's difficult to apply. We do have the concept of piercing the corporate veil, where you can look through a company to see what lies behind and who are the shareholders. So that's a possibility. And then we have the PPT, which has been discussed today and in this Congress. And it was said that the PPT is stronger, more comprehensive, and I would agree with that. It was also mentioned by João and I think by Blazej that the introduction of LOB clauses is a possibility. I'm not sure that's likely. In the short term, I can't see that happening. And I would say that it's going to be quite difficult. While everybody said the BO is not so important anymore, I don't think it's going to be easy to get rid of it. But I do think that maybe it doesn't matter because it's always been solved in a different way. And now the different way is going to be to apply the PPT. And if we look at the definition, which has been recently introduced in recommendation 24 of the FATF, it doesn't introduce anything different. And I would think we do not need a precise definition. And I don't know if this can be done. Yeah, I think it's too late. I think to come up now with a precise definition is not going to work. And there's no evidence to suggest that the general global understanding of beneficial ownership has led to treaty shopping. It might not have combated treaty shopping. And so this has led to different actions and the introduction of the PPT, which might solve it in a better way. But I don't think it did any particular harm. And I would say that full disclosures under the various organizations who are collecting and exchanging information seem to be the determinants for revealing beneficial ownership, without us having to have a subjective debate about it. So I would think that probably the term beneficial ownership has really been exhausted. And I've drawn my comments from a lot of writings on beneficial ownership, just to realize how difficult it is to come up with an answer for it. But I'm not sure we need to. I think, as has been suggested, maybe the beneficial ownership is the first step. And if that is established, you then move on to the PPT and take that forward. So having said that, I just wanted to add more context to the proponents of, oh, let's just get rid of the term. I don't think it's that easy. It does appear in a lot of our treaties, and we know that they're not going to change treaties overnight. And maybe something will come along that we don't have to do that. And I think that's what we've been hobbling along in that situation for many years. And it hasn't become crucial. And I'm not sure it's crucial now. So maybe in the background, it's not such a bad thing to keep as a stepping stone to then, as Patricia was saying, to follow the path. And I would suggest to say that beneficial ownership is like tofu. It takes on the color of the context. And in the past, we've used the context to actually then come up with an answer. And I think if it remains in that position, I don't see a real problem with it. Anyway, I thank you. I've just added some thoughts to the whole process. Thank you very much.
Ok, muito obrigado, professora Jennifer, pela apresentação maravilhosa, realmente muito completa, muitas coisas para pensarmos depois desses debates intensos. Gostaria de agradecer a todos os participantes, a todos os speakers, ao nosso presidente, Paulo Caliendo, ao professor Blazej, que tinha uma reunião pré-agendada, saiu agora há pouco, 2 minutos atrás. Agradecer a todos. Thank you very much for your participation, for your collaboration, and for your friendship in this time that we are preparing the conference. E obrigado a todos. Perguntas vão ser respondidas no painel de Questions and Answers a partir das 17h30. Obrigado a todos. Obrigado pela honra e tchau.